Section 8. Contempt by members of the House of Commons. Another memorable example of habeas corpus occurred in 1628. During the reign of Charles I, it arose from the imprisonment of members of the House of Commons for their speeches and conduct in Parliament. The Speaker had delivered the King's message, commanding him to adjourn the House, and put no question. This power of adjournment the House claimed to be inherent in themselves, and several members said that after they had settled some things convenient to be spoken of, they would satisfy the King. Sir John Eliot then offered a remonstrance concerning tonnage and poundage. When this was offered to be put to the question, the Speaker refused, on account of the King's command, to rise after his message had been delivered. He rose and left the chair, but was drawn to it again by Mr. Hollis, Valentine, and other members. Mr. Hollis, notwithstanding Sir Thomas Edmunds and other privy councillors endeavoured to free the Speaker, swore, God's wounds, he should sit still till it pleased them to rise. The articles of protestation were read and aloud with a loud voice by the House. Warrants were issued by the Council, commanding the personal appearance of Eliot, who, we are informed, afterwards died, a victim of imprisonment in this affair. The learned and patriotic Selden, and other members of the Parliament. The members summoned by the Council refused to answer for what was done in Parliament, and were committed to the Marshal of the King's Bench. The members were brought before the King's Bench on habeas corpus in Easter term of the year of their commitment, 1629. The returns showed, first, that they were committed by virtue of a warrant under the hands of 12 privy councillors, without any cause shown, and which was contrary to the petition of right. Secondly, that they were also detained by virtue of a warrant under His Majesty's hand, and commanding the Marshal to take notice that the previous commitment was for notable contempt, committed against ourself and our government, and for stirring up sedition against us. 2. Easter term was lost, but on the first day of Trinity term, when the court was ready to have delivered its opinion upon these writs of habeas corpus, the prisoners were not brought to the bar, according to the rule of the court. The Marshal of the King's Bench, however, appeared and informed the court that his prisoners had been removed the day before, and put in the Tower of London by the King's own warrant. On the evening before the day for judgment, the King had written several letters to the judges, informing them why the prisoners were not suffered to come at the day appointed. The King was at first inclined to favour that great lawyer, Selden, one of the prisoners, and Valentine, and let them go before the court at the appointed time. This was intimated in one of his letters, but he immediately changed his mind, countermanded his instructions to that effect, and resolved that they all should receive the same treatment, and that none of them should go before the court until we have cause given us to believe they will make a better demonstration of their modesty and civility, both towards us and your lordships, than at their last appearance they did. So the court delivered no opinion this term, and the imprisoned gentlemen continued in restraint all the long vacation. Towards the latter end of this term, on Michaelmas Day, the Chief Justice and Judge Whitlock of the King's Bench, and the King himself, at Hampton, talked over the matter of the gentlemen's imprisonment in the Tower. The King was willing, notwithstanding the prisoners' obstinacy, to let them be bailed, provided they would express that they were sorry he was offended with them. He manifested his intention to proceed against them by the common law in the King's Bench, and to have his proceeding in the Star Chamber. But the judges said that the offences were not capital, and that by law the prisoners ought to be bailed, giving security for their good behaviour. At the conclusion of the good offices which these judges did to cause a healing of the breach, the King said that he would never be offended with his judges, so they dealt plainly with him, and did not answer him by oracles and riddles. So a motion was made to bail the prisoners. This was unanimously granted by the court, provided the prisoners would find sureties for their good behaviour. But with this condition the prisoners refused to comply, therein acting up to the motto which Selden chose for one of his prison lucubrations at this juncture, Swords arc to intervincula recusat. These arbitrary and high-handed proceedings were at the instance of a king who, we are informed, inscribed upon his coins, Relic prot leg ang liber pal. What became of the prisoners will be made known in the next section.